All right, everyone. Prepping for the Queensland Bar exam? Listen up. You know that getting your head around expert evidence is an absolute must. So let's break down the essential rules you really need to have locked in. What we're going to do here is give you a clear, solid framework for Chapter 11, Part 5 of the Uniform Civil Procedure Rules. We're talking core principles, the latest changes, and the key points you'll need to nail on exam day.
Okay, let's get straight into it. We have to start with the foundation. What's the whole point of these rules anyway? Well, if you look at Rule 423, it's all about creating a clear system for controlling expert evidence.
You can think of the UCPR as setting up four main pillars here. First, giving the court control. Second, making it crystal clear what an expert's duty is, and spoiler alert, it's to the court, not the person who's paying them. And third and fourth, streamlining how all this evidence gets presented, whether through reports or by using joint experts.
Now, here's where things get really interesting. A huge shift happened with the Uniform Civil Procedure Amendment Rule in 2022. It completely replaced the old Part 5, and trust me, this is a massive development that you absolutely have to be across for the exam.
And this really gets to the heart of the matter. Before 2022, the rules sort of pushed everyone towards using a single expert by default. Well, that's gone. Forget about it. The focus now is all about judicial discretion. It empowers the court to make whatever direction is right for that specific case. Okay, so we know the purpose, but just as critical for the exam is knowing the boundaries. In other words, when does Part 5 not apply? Rule 424 gives us some really important exceptions. Take your client's treating doctor, for example. When they get on the stand and testify only about the treatment they actually provided, these rules don't apply. Why? Because in that moment, they're a witness of fact, not an expert giving a specialized opinion. That distinction is key. Right. To use these rules properly, you've got to speak the language. So let's quickly nail down the key terms from Rule 425. This is your essential vocabulary list.
First up, expert. Now, the definition is all tied to qualification. This isn't just someone who knows a lot about something. It's a person who is qualified to give opinion evidence on a specific issue in the case. And that's the whole point. Their job is to provide an opinion, which is a rare exception to the general rule that witnesses can only talk about facts they've observed.
Next, the report. Simple enough, right? This is the official document where that expert's opinion is all written down. Under these rules, that report often becomes the expert's main evidence, which means its structure and what's inside it are incredibly important.
And finally, the Code of Conduct. Look, this one is absolutely non-negotiable. It's in Schedule 1C, and it spells out that an expert's #1 duty is to the court, not their client. Every single report has to include a statement from the expert saying they've read the code and agreed to it. You have to be familiar with this.
Okay, now we get to the really practical stuff. How do, and more importantly, how does the court actually manage all this expert evidence? It all comes down to the power to give directions.
This one sentence from Rule 427.1 is just incredibly powerful. It gives the court massive, flexible authority to control expert evidence. And notice those three little words, at any time. The court can jump in and do this whenever it wants, even without a party asking.
And Rule 427.2 gives us a taste of what that looks like. It's not a complete list, but the court can limit how many experts you can call, make them talk to each other before they write the reports, or even order an expert to combine a bunch of reports into one. This is the court's toolkit for keeping things efficient and fair.
Okay, that was a fair bit to get through, so let's boil it all down. What are the absolute must-know points that you should have front and center in your mind when you're prepping for this exam?
Look, if you walk away with anything, make it these three things. 1. The massive 2022 shift to judicial discretion. 2. Know the exceptions in Rule 424, backwards and forwards. And 3. Really understand the court's massive toolkit for giving directions under Rule 427. These 3 points are the absolute heart of Part 5.
So, I'll leave you with this question to think about. These rules aren't just for memorizing. They are tools in your arsenal. As a barrister, you can actively apply for these directions. Start thinking now about how you could use them strategically to shape the evidence and advance your client's case. That's the difference between just knowing the law and actually practicing it.